Thank you. Could I then, on your main case, which is the question you pose for the court to answer is it a defense to spoliation that you have statutory authorizations? Is that correct?
Yes.
Now, there is a case of the Supreme Court of Appeal called Street Pole Ads versus eThekwini Municipality. Are you familiar with that case?
No.
All right. It's reported, perhaps you can deal with it after the adjournment. It's reported in 2008, Volume 5, SA 290. It's a judgment by Justice Cameron. And he says that in a spoliation case, if an applicant goes further than the traditional grounds of spoliation and relies on the substantive right of possession, such as title to ownership or contract, then it is permissible for a respondent to enter the merits of the right to possess. And in that case, he said that it was permissible because what the municipality had done was not only to cite a spoliation, but also to go beyond the spoliation and to ask for an interdict. It struck me that that case is analogous to what we are dealing with here, which would then mean that Justice Makgoba was not incorrect necessarily in paragraph 53 of the judgment when he found that it was permissible for him to look at the right of possession of your client and the right of possession of Nkwe, both of which are competing statutory authorizations. So I wonder if you have submissions to make on that point.
Yes, and the submissions are, our case was never that we, so the case of MPM was that it relied on its occupation and a spoliation application. That was its case. The interdict case was simply, first it was in the alternative, and second it was simply a case of you've breached a statutory requirement, and if you've breached that, we're entitled to the interdict. So the case you refer to, the judgment by Cameron J.A., is not analogous because it's not an analogous situation. MPM didn't rely, for example, on a contract with Nkwe or anything of that nature. It simply said, well, we were in possession. Of course, the context of its possession is that it held a mining right. And it said, as a result of that mining right, we took possession and we were there. We occupied it since 2002, the property.
Well, isn't that the problem? That the possession is not a common law possession, it's a mining right possession.
No, but it doesn't matter what the nature of the possession is. In fact, it can even be illegal possession. If you're in possession, you're entitled to a spoliation application. So it doesn't really matter.
Yes. And the pleadings in this case also rely on the mining right as creating the possession.
No. So obviously, it's a...
Yes, could we... You're saying that they don't?
No, I'm saying this. Obviously, the context is not irrelevant. And what MPM did was it said, we're in possession. And we got there, we're in possession because this is how we got here. We got here through a mining right. And we're in possession, and we have been in possession since 2002. Well, assume...
But 2002 is just the start of the mining right.
Yes, but it continues since then. It stays in possession.
Well, that's the problem I have with the case. The way it's pleaded, this is the point, it's not a new point, it's the point that Justice Savage put to you. The way the case is pleaded is that what was spoliated was the mining right itself.
No.
Well, perhaps you can help me to understand the pleadings better. If you go to the founding affidavit, which is volume 1. So, paragraph 3.10 of the founding affidavit. And then you go to the summary of the case, paragraph 4 of the founding affidavit. And then you go to paragraph 5.7 of the founding affidavit. and then paragraph 5.11 of the founding affidavit. And paragraph 10.2.1 of the founding affidavit.
Look at
All of those paragraphs suggest that the complaint about what is spoliated is the mining right itself. So that's why I'm saying maybe you can help me to understand these pleadings better.
Well, so, I mean, even a right can be spoliated. We know this. Incorporeal can be spoliated.
I accept that fully, but I'm simply trying to understand that your client's complaint was that what was spoliated was that right, but as a matter of law, it's correct that a right can be spoliated.
Yes.
Yes.
Yes. But its case is that it was in undisturbed occupation, and Inque took occupation of its mining area without its consent. I mean, that is the case. I mean, if those are the facts, then we say that's good enough for spoliation.
Yes. Could I then ask you a different point? Perhaps you can come back on this. I understand that. A different question. On the remedy itself, what we have with, even before this new application came, we already have enough evidence that the area basically had been built up by Inquire. Is your case that the constitutional requirement of justice and equity doesn't apply to spoliation?
No, it doesn't.
I mean, I also struggle with that principle. Why would a spoliation not be tempered by the requirements of justice and equity, which are constitutional requirements?
Well, we set out in our heads why it wouldn't be, because we refer you to, is it the, just find it in my head, it's the case of, it's the case in the SCA, sorry, no, in the Constitutional Court, I think. Let's find that. Yes, here we are. We say in our heads of paragraph, sorry, from page 15 onwards, courts can make just and remedial orders to resolve disputes over constitutional rights that involve social and policy problems, and they may do so in a way that promotes the parties themselves. That's the word called the Ermelo case. There, the Constitutional Court says why it does this. So they may do so in a way that promotes the parties themselves offering solutions, and in a way that is practical through structural interdicts or supervisory orders. This approach was confirmed in later judgments, and we give you the judgment at footnote 25, I think. Now, we say that approach can't apply to a spoliation application because Ngukumba provides a remedy that stops self-help. I mean, that's the remedy to stop self-help. There isn't a more just and equitable way of stopping self-help other than ordering restoration. I mean, how else do you stop self-help? Because, of course, what you've got to do then is the parties have got to go back, as it were, to the underlying situation where either their rights are resolved in court or by way of arbitration or by way of agreement, whatever. But until that, I mean, that can't happen at this stage. We can't get into a debate about how best do we sort of resolve this problem. That's not the purpose of spoliation or spoliation remedies. Its purpose is to resolve one and one problem only, and restore ante omnia, so that the parties can then pursue whatever remedies they have in law.
Thank you, Chief Justice.
I think, sorry, forgive me. I was going to say that I think I've overstepped my time. But